I'd just like to ask that we continue to be open to the learning and to the teaching that is going to be given today from David from NICWA, and that you all, have questions and you put them in the chat box, knowing that we all are continued students of this beautiful work that we do for our Indian children and families. So thank you for being here, and I'm going to turn it over to David at this moment. Thank you.
Okay. All right. Well, good morning, everybody. Thank you. Happy Monday morning, start of a new week. And thank you for all of you who were able to attend last Friday. And for any of you who weren't, who are attending today, welcome. So we're very excited. So last Friday, we spent time covering some of the background, federal policy, the need for ICWA even today. We talked about trauma and how trauma impacts children and families, and specifically some of the impacts to Native communities and families. And so today we're going to focus more on just the Indian Child Welfare Act itself, its basic requirements. We're going to talk a little bit about some of the, we'll call them tips or issues around practice for child advocates. And we'll have a little bit at the end to talk a little bit about what we call protective factors. And how those are important in helping the healing and the protection of children too. So I'm going to start, Ryan is going to queue up a movie here in just a minute. It's just a short video that we have done. We did 4 videos called The Heart of ICWA. And there are people with lived experience who are involved with the Indian Child Welfare Act at one level or another, just kind of sharing their own experiences. And we love, in the work that we do, we are always trying to think about, especially for the challenging issues, about how we can humanize, the work that we do. It's easy to get lost in the data and sometimes, and some of the politics and things, but we're going to look at this video, and I'll give you I think a really unique picture of one person's experience, 3 generations actually. So excited about that. And then we'll of course, move through the different parts of the Indian Child Welfare Act. We're not going to really we don't have enough time to probably cover everything under ICWA. So we probably won't be talking much about voluntary placements and consent, but we'll see. We'll see how much time we have. We have time, we'll definitely go there. But nonetheless, in the handout you have the slides, it does have those slides in there, so you can look at those later too. I guess the only thing I have left is just to say about the chat box. Laura was telling us a little bit about how you can use the chat box. Ryan was. So we're going to have some places where we're going to have chat box exercises. And at those times, we'll have some questions, and then we'll just ask you to put your responses into the chat box, and we can all kind of share that information together. So I'll let you know when that comes up. It'll be pretty obvious. But I think, Ryan, we're ready to go unless anybody has questions about just basics or housekeeping things. Okay. Ryan, you're on mute, so I'm just seeing your head nod. So, okay, if you want to go ahead and start the video, that's fine.
I can introduce myself. Week Uya Mhan Rhonda Kwededaka Nahagutana Iite, which means my friends, Rhonda is my name, and I'm of the Cow Creek people. You're gonna learn that someday. Joseph, my grandson. Joseph's 8 years old, and he's quite the little joy. He's a very smart little boy. It's important for him to learn the Gelma language because he'll know this is where he comes from, this is where our people come from. I worked for the tribe for the last 24, almost 25 years, from human services, ICWA worker, to the cultural department. Being an ICWA worker for the tribe, I was immersed in all of the court battles, the caseworkers, the parents, the kids missing their families, their homes. Looking at my life over the last 10 years, my last husband passed away. My daughter moved out, my stepson moved out. So it was a good time to start taking in Native kids. I took in Tessa, Jesse, and Brittany, who were also my cousins, and started a journey with them. They went into foster care when they were like 5, 7, and 9. And we had been trying to get the states to work together to allow these 3 kids to go to their grandpa in Alaska. Grandpa was working, Grandpa had his own house, Grandpa had everything that the kids needed. The states wouldn't let them go. I believe ICWA wasn't being complied with when they didn't allow the kids to go with their grandparent. I remember thinking, I can't let these kids go into another foster home, who knows where. I knew their history. I knew their life prior to foster care. I knew their life in foster care. Those 3 had been through the ringer. And I knew that I can't let them go. My situation was I was single, healing from my husband's death, and finally at a point where I just can't let these kids go through more hell. So I have the ability to be a foster parent. So I decided I was going to take them. They were definitely little injured souls, angry, loving at the same time. Tessa, who is the oldest of these 3, when she came to me, she was pregnant with Joseph, and she was 15. She was young. So pretty soon, here was a newborn in the house. It was tough. It was really tough, but we made it. ICWA helped keep my family together. Had ICWA not been in place, what would their lives have been like? Tessa with Joseph, a young teen mom having a baby, chances are him being put back into the system. And because of the ICWA Act, they were able to stay with family, with relatives, within the community to help strengthen them back to who they are as a people. ICWA serves to keep families together. The root of it is culture. Culture is important because it keeps you grounded. You know your roots. You know where you come from. If you break that connection, kids are going to be lost. ICWA has a beating heart. Every life that it touches, that's one beat. It's one beat. And how many kids, how many families, aunts, uncles, grandmas, grandpas has this touched? It's important to look at these things through a child's eyes, and how important it is for a child to be able to stay with their family, stay with the people who know them and love them the best.
All right, thank you, Ryan. So as I said earlier, we have 4 different videos. That was one of the 4. And if you just Google Heart of ICWA, you'll find the other 3 videos and this one too. Or just Google NICWA YouTube channel. That's maybe, you can find it there as well. And we've tried to create a collection of different stories from different perspectives of people who've been touched by the Indian Child Welfare Act in their lives, and also in the communities too. And so there's a tribal leader, there's a foster parents, relative. So we've got, and then also an adult adoptee. So you've got a number of different kind of perspectives there, and I think they're really helpful. Thanks, Ryan, for putting that there. There's a link right there in the chat box right now. So we're going to jump right in here. We're going to jump into the Indian Child Welfare Act. So what I'm going to do is I'm going to share my screen here. All right, we're going to get to the slideshow. All right. I got to get. So we're starting kind of in the beginning here. We're going to start with just the application. And so the Indian Child Welfare Act is a federal law that applies to all state child custody proceedings. That's important to know. It's not tribal child custody proceedings. Those happen under tribal law, but state child custody proceedings are what ICWA applies to. And to have application, it has to involve an Indian child that's unmarried, under 18 years of age, and is either currently a tribal member or is a child of a tribal member, and the child themselves is eligible for membership. So when we think about the kind of cases that you may come into contact with, there's certainly a number of cases where the parents are already tribal members, but there's also at least as many where they're not. And, just thinking about sort of the life experiences of many of the families in child welfare, they sometimes things like getting your kids enrolled in their tribe is maybe not the first priority at some place. And so a lot of the kids are going to be eligible, and even the parents sometimes are eligible too and could become tribal members very quickly. So sometimes the question is, well, what if I'm dealing with a family and one parent's a tribal member, but one parent's not, the children aren't enrolled yet? Well, if you think about this and you're trying to support the Indian Child Welfare Act, that what could happen is that the child is going to become eligible or could become an enrolled member very quickly. So thinking about how child welfare proceedings go from emergency placement all the way through permanency, it could take months, if not longer. Then it's very possible that somewhere down the line there, you're going to have that child become eligible. So it's best really in the beginning is to take a liberal look at that eligibility and determine how can I help support both the parents and the children, making sure that they get enrolled in their tribe or tribes. So another thing I would say about this is that sometimes in some families, we have a lot of blended families, you might find that the tribe that the child is eligible for membership in is not necessarily the same tribe as one of the members or one of the parents and what tribe they might be eligible for. So just be careful about that. So the child, depending on what their heritage is, where their descendancy, they might be eligible in more than one tribe or not necessarily the same tribe as their parent, maybe a different tribe from another parent. So it's important to look at that. And the other thing is that it's a federally recognized tribe that we're talking about. So not a state recognized tribe, it's a federally recognized tribe. So there's a list of federally recognized tribes and their ICWA contacts that you can find on the Bureau of Indian Affairs website. And all of the tribes have listed some, either a person or an address or both, that you can contact or some way of contacting. So this is the part, as we're trying to figure out about the application, we call it the inquiry part of it. It's different than notice. We'll talk about that later. Notice is where we're noticing the proceedings, the court proceedings that are coming up. But this is the inquiry process, and it's important to try and get engaged with this as early as possible. I even suggest, if hopefully maybe you're in a state where they actually start the inquiry at even intake, when they're thinking about screening in or screening out a case. And in Washington, that's one of those cases, that's one of those states. So it's really good to even just be asking it, depending on when you come into the picture in your work, is to say, what kind of efforts have we made to inquire about whether this is an Indian child or not? The court it should be asking that question at the very first proceeding. Caseworkers should be asking those questions, and as child advocates, you should be asking that question too. Doesn't hurt to have more people ask that question. It's possible that somebody missed something along the way. So when I say child custody proceeding, what kind of proceedings are we talking about? Well, there's a few different kinds of proceedings. And before I jump in there, I wanted to kind of give a refresher. Down here, you see this kind of gobbledygook at the bottom, and you're going, what is all of that? Well, that is citations to the specific parts of the law that support the different information that we're talking about on these slides. So for instance, 25 USC, and then that stands for United States Code, and then that little squiggly mark is a section mark. So section 1903(1). So that's the area of the statute where this particular information comes from. And then right after that, it says 25 CFR section 23.103. Well, that's 25 Code of Federal Regulations. So here's the accompanying regulations, 23.103 section. And then the last one is FR, Federal Register, section A.2 and A.3A. Well, the Federal Register is a place where they where it's published, where they place regulations, but they also put in those guidelines. And so there are guidelines. Guidelines don't have the force of law, but it's really suggested practice, we'll say best practice. And so the Bureau of Indian Affairs put out guidelines. They revised those in 2016. And so that's where you can find some of this information too. This is one of the things I think I mentioned last week if you were on it. Sometimes when you share your screen as a presenter, you lose some of the information. Or you lose the ability. Okay, there we go. Thank goodness. Sometimes my controls go away. So the types of, it's both voluntary and involuntary child custody proceedings that ICWA applies to. So foster care placement is defined broadly. It's not just your traditional foster care placement. It's also institutional / congregate / residential care. It's conservatorship or guardianship placements too. So foster care placement is actually defined pretty broadly. ICWA also covers termination of parental rights proceedings and pre-adoptive placement, which happens usually after termination of parental rights, but prior to the actual adoption being finalized. And then of course, an adoptive placement, both voluntary and involuntary, and that applies to foster care and the others too. So we're going to be focusing mostly on involuntary today, but there will be times where we'll have a little conversation maybe about involuntary or voluntary, excuse me. So there are some other child custody type proceedings that are covered. And sometimes what happens is that we don't think of these as necessarily as covered by ICWA, but they are indeed covered by it. So the first would be a status offense. So sometimes status offenses are handled in the juvenile justice system, but sometimes they're also linked to the child welfare system too. So things like truancy or incorrigibility, not being able, child is sort of difficult to handle, usually older kids. And in this offense, the status offense, it's a situation that results in a foster care or termination of parental rights or adoption. So it's an out-of-home placement. So what is a status offense? Well, status offense is something that if an adult committed it, it would not be a crime. But if a younger person commits it, a minor, then it could be considered a violation. It's not a criminal violation, but it is a status offense. So we see kids who are runaways, truant from school, just difficult, kind of hanging out, causing problems. Those are the kinds of things that often can be brought to a court as a status offense. So you would apply ICWA similarly to you would in those other proceedings, those other kinds of placements and proceedings. And important to know is that a status offense can sometimes be, as I said, in either the child welfare or the juvenile justice system, and it can be linked. So you can have a child welfare proceeding on a status offense that's happening at the same time that there's a juvenile delinquency proceeding where somebody did violate a criminal statute. So if somebody, for instance, you have a juvenile who was kind of just not going to school and truant most of the time, but in a separate event, maybe was involved in some kind of theft or robbery or something, that could be a situation where you would have a juvenile delinquency proceeding for one for the crime and a status offense for the other. If there's that, there should be that kind of separation, and the Indian Child Welfare Act should apply in the status offense piece of that. So, it's not unusual for especially teenagers who have been a part of the child welfare or the juvenile justice system for a while to be involved in both at the same time. Now, having said that, there are some proceedings that are not covered by ICWA. And we've got some examples here. So divorce and separation proceedings, we take about 1,000 calls every year from parents and relatives and child welfare professionals, attorneys, who have questions about ICWA. And one of the most common ones is whether or not ICWA applies in a divorce or separation proceeding. You might have two parents, whether they were married or not, who are not living together, and then there's a proceeding where they're fighting over custody. So it's a child custody dispute involved. Those are not covered by ICWA. So that would be covered by typically state or tribal law, depending on where the proceeding is happening. And then juvenile delinquency proceedings, kind of pure juvenile delinquency proceeding that's based on a criminal violation. That's where you would find ICWA would not be applying in that situation too. So if it's a crime, and then it's not going to be covered under ICWA. So how do we get to the place where the courts and the agencies are able to know what their kind of instructions are, and whether you're working with a child, an Indian child or not? Well, the first thing you really have to do is you just have to ask the question. So in the regulations, the state court is required to ask each participant in that proceeding if they know or have reason to know if a child is an Indian child. So in that situation, it's going to happen in the court, but really before you even get to court, people should be asking that question earlier than that. That would be, in my opinion, that's a little bit later than it needs to happen. We should be asking that question as soon as we have contact with the child or the family, whether that's even before that emergency proceeding and during intake, just to see if we can get as much information as we can. So when we get to court, we'll have already a jump start on this. And of course, doing the inquiry right and doing a diligent process early helps us to apply ICWA accurately and helps us to avoid having to either redo proceedings earlier or having to have delays maybe in the future. So if people say, well, there's a reason to know, but we can't confirm it, the court has to confirm that due diligence was used to identify and work with the child's tribe or tribes, and they have to treat the child as an Indian child until it is confirmed. So it might take, in some cases, you might get quick verification from some tribes about whether a child is considered a member or not, or eligible for membership. In other situations, it may take a while. So like, tribes or sovereign governments have their own processes as to how they and when they do membership and enrollment. And so, not every tribe is the same, and some may have more resources in this area than others, so it may take more time. And one of the greatest helps in this is making sure that people have sufficient information. So as when you're contacting the tribe, this may be one of the first contacts that the tribal enrollment office or the child welfare office has about this family. And so any information that you've gleaned through your involvement may be really helpful in that kind of membership enrollment process. WISC WICWA, which is basically Washington State Indian Child Welfare Act. So in Washington, you have your own state ICWA as well as you've got the federal ICWA as to apply. And in many states, there are over, I think 8 or 9 or 10 states that have their own state ICWA laws. Oregon has one now too. And so the state ICWA laws oftentimes they follow, of course, the federal law. They need to do that. So the same standard is there, but they can go above and beyond that too. And in the Washington State ICWA, they provide a higher level of care and maybe more specificity in some areas of the federal, where the federal law applies. And the Washington State ICWA law is, I think, one of the older ICWA laws on the books, not the oldest, but one of the older ones. And so take a look and become familiar with that as well. So it says that in this inquiry process, you have to make a good faith effort to determine if the child is an Indian child. And then they give you some ideas about that, like consultation with the child's parents, any person who has custody or had custody of the child previously, any person that recently we expected to have information. So thinking creatively about where could this information come from. Then I'll give you an example. You might be working with a child and a family who have been living in an urban area for some time, let's say Seattle or maybe Olympia or somewhere. But at one point, one or both of the parents may have lived somewhere else. Maybe they lived close to an Indian reservation, or tribal lands. But and so that might be a clue in and of itself that there's potentially could be some Native heritage there. And so wanting to get as much information about the family as possible to just help you, because you might ask the family and they say, well, might have been some there was a rumor in the family, or we had some relatives that lived on a reservation, but we really don't have a lot more information. Well, you want to be following up on that kind of information just to help kind of pinpoint it out. And the family may not have a lot of specific information. And so it will be up to you to try and help the court and also the caseworkers to be able to help kind of close the gap in that information. So here we've got some examples of what would be a reason to know. This is provided in the regulations for the Indian Child Welfare Act, the federal law. And it talks about has reason to know a child is an Indian child if, and then it talks about anybody in the court proceeding has been informed that the child is an Indian child or has information related to that, gives the court reason to believe. There's a domicile residence. So domicile means that this is sort of where you consider to be your permanent home. You might be going to school or working in a seasonal job or something just to make money away from what your domicile is. That would be your residence. So and we see this in Indian country, the population is fairly mobile. So if you see that, asking somebody about, well, where do you consider to be your permanent home? Might help you understand domicile, which could be on or near tribal land somewhere too. The child is or has been a ward of a tribal court. It's a good question to have asked. Does anybody have information about this? A parent or a child possesses a tribal ID card. That would be fairly obvious, I guess. And then parent request for anonymity does not relieve the party from the duty to comply. So in other words, you might have a parent, especially maybe in even an adoption situation, where they might be saying, well, I'm just a little nervous about contacting the tribe right now, or I've got my reasons. That's okay. The Indian Child Welfare Act allows for some of that anonymity and confidentiality, of course, but it also doesn't relieve the parties in the case from complying with ICWA, which also includes trying to determine the child's membership. Now we're getting to the notice. Now, this is not inquiry. And so some people get these mixed up, but notice is really notifying somebody that you have a proceeding coming up. And so it could be any one of those proceedings I mentioned earlier, the foster care, termination of parental rights, adoption. And so the notice must be sent by registered or certified mail with return receipt to the child's child's parent. You can't cut this short. So in other words, you can't say, well, I made a phone call or I sent an email. You've got to follow the statute requirements and the regulations. Now, one thing that they did do, which was a little bit of an expansion in the regulations, is that they said that the notice you should just say sent by registered mail. Now it's registered or certified mail. I think certified mail didn't exist in like 1978. I'm not 100% sure about that, but I think it wasn't utilized. But now certified mail is maybe a little easier standard, but it still provides that kind of documentation, that chain of custody documentation that you need. And so it's still required that when you're going to have a proceeding, you've got to provide that notice. And the notice is required for each proceeding and each one after too. So proceedings also include hearings within them. You might have one proceeding around foster care, but have a number of different hearings on different issues related to that. So notice is required for proceedings, not for each hearing. But I think the best practice is to provide notice, making sure that you want people to be there. So you want to provide the best kind of notice that you can. But that's a best practice. It's not necessarily a requirement to provide that legal registered or certified mail notice in each hearing if you've already provided it in the proceeding, but it is a good practice. So be thinking about that. Emergency proceedings require notice, but not formal notice. So when I say formal notice, I mean the registered or certified mail. I refer to it as legal notice sometimes, or formal notice. So in this situation, because emergency proceedings can happen so quickly, you can use a more informal process like phone and email, fax, things like that. And it's highly encouraged that you do that. And it's required that you provide some form of notice to the child's tribe and their parents, or an Indian custodian if that's applicable. So you can do this, and actually I say even in the registered or certified mail, it doesn't hurt to follow up with a phone call or maybe an email to somebody there at the child welfare program, just to say, hey, this is coming your way. I wondered if we could talk to you about the case a little bit more and sort of what's going on. Just helps kind of promote more timely and early engagement and collaboration. And so I think that's also one of those things that I recommend, is just to kind of make sure. So in your role as a child advocate, thinking about, have these things happened? Who's handling it? Where are we at status wise? Those are the things, because it's like in many areas of life, we don't want too many surprises in child welfare. So we want to do the best we can to make sure that everybody involved is sort of on the same page. I mentioned before that there is a list of tribal agents, as they're called, information. And so the Bureau of Indian Affairs website has that. If you go under there and look for ICWA, you'll see they have that list. They update that list about every 2 years. So it's not guaranteed to be completely accurate all the time, but it is in a good place. And sometimes you might be working with a child and a family, and they don't have very specific information about their tribal heritage. If you have an idea, like let's say that they say, well, we're Lakota, or we think we're Lakota, for instance, that there's more than one tribe that is from the tribes that claim Lakota heritage. And those are typically Sioux tribes that are in the Midwest, the upper Midwest and the plains. So another tip is to contact the Bureau of Indian Affairs regional office. Each BIA in each region, the Bureau of Indian Affairs has a regional office. You can see that on their website too, and ask for their social worker. They have a regional social worker. That person might be familiar with potentially the family name of that child, or one of the parents might say, oh, that sounds like a name that comes from this tribal community, be able to help you find that information or others. and be able to help you get in contact with that tribe, cut down on some of the time that it would take for you to do that. So it's good, and it's a good way. The Bureau of Indian Affairs is not going to be handling your notice necessarily and doing all the work that the child's tribe would. They're not going to appear in court, in other words, but they can be a resource to you in that process. So if a parent or any custodian appears without an attorney, and this does happen sometimes, the court has to inform them that they have a right to counsel, legal counsel, and they have a right to petition to also transfer the case from state court to tribal court, and a right to object to transfer if somebody else is asking for it, like the tribe, and a right to request additional time, and a right to intervene. So all of these are rights for the parent or custodian, and many of the family members don't know about all these rights. They haven't had anybody. They might even have an attorney if they appearing with them who isn't themselves completely knowledgeable about all of these things too. So I think in a child advocacy role, this is an opportune time to really inquire if the parents really have all of the information they need to make good decisions as well. And this is especially true, I think, sometimes when the tribe hasn't intervened yet, or you're waiting on information. It might be that there's some miscommunication or lack of knowledge that people have that would be helpful. So here's our first chat box exercise. And so what we were asking you to do is just go to the chat box and just pick one of these questions or respond to both, it doesn't matter. And just throw something in the chat box related to this about your role and how you see how you've done this work, or some things you might, even if you haven't had a NICWA case, how you might, some things you think might be helpful. Because these are in critical functions here. And so we just want to see that. And Laura Lee is going to kind of pick out a few of these and just let us know what you put in the chat box.
Thanks, David. Is DNA testing okay?
For a matter of what?
What this brings to my mind, and it's from Jan, and I know the Kalispell tribe do DNA on a child to make sure that they are of that or the family. So I think it depends on the tribe.
I think when somebody's maybe there's a question about paternity.
Yes.
And certainly DNA can come into play there.
Yes.
But in terms of like using DNA testing to identify, you might be able to, as these tools get better and better, be able to identify that the child is a member of a particular group of tribes. That seems to be where we're at right now with like 23andMe and Ancestry and some of those. I don't know that it's going to be necessarily help you, figure out which tribe specifically the child might be eligible for membership in. So just wanting to be careful, because what if you got a DNA test back and it says, oh, well, it doesn't look like this child has any native ancestry or none or around here. I would hate for somebody to use that as the basis, the complete basis for then moving on and assuming ICWA didn't apply. So that would probably be potentially a mistake.
Yes. Because they would have to do tribal members to find out. Yeah. And
really, it's worth repeating, I guess, that the tribe is the only entity that can actually make determinations about tribal membership. So you might even be able to go on a website and look at their, find a copy of their constitution, or maybe even their enrollment criteria. But you never know, is that actually accurate? Because sometimes things get changed over time, and maybe the resource on the internet isn't correct. And it's really, as I say, let's leave it to the experts. We would never allow, the country of Spain to determine who our members are in the United States, because it's a sovereign right. It's what we do. We don't allow other people to do that. And so the same thing goes for children who are potentially eligible for tribal membership. The tribe is the one who should be making those determinations.
Right, correct. And I do have one that says, and it's from Christina. And I'm just going to respond to this. Christina, I think we can reach out to the tribe and build that relationship with the tribe, but the social worker and their programs will help the parents find the requirements that they need to get for membership and stuff. A lot of just a lot of comments so far, David.
Great.
Because they're talking about ICWA. I mean, they're talking about, you know, the NAIR process and NICWA, which will be addressed tomorrow by two very well qualified people. And here's a question by Greg. How do you support timely response on the part of a tribe? There's two parts. I am thinking when the response is not yes or no, you just don't hear back. When does the reasonable effort time clock run out? That I hear a lot, David. Do you want to address that one?
Yeah. Well, you know, the statute said, or the regulations say two things. One is that they say, which was in my earlier slide, that if you have a reason to know that the child may be an Indian child as defined by ICWA, you have to continue through those proceedings to treat that as that child as an Indian child and apply ICWA accordingly. At the same time, it does provide the court, without specific timeline, the opportunity if, for instance, they have that reason to know, but they're just not getting confirmation from the tribe. The court at some point can make a decision that we don't have anything to confirm or deny this, and so we're going to move on, and this is going to be a non-native case. But that is, as I said, that is not something that they provide a timeline. They don't say 6 months from the beginning of the first proceeding or 9 months. So I would think, you know, as I've experienced ICWA myself, sometimes it can take several months to get that sorted out. So it's probably best not to be doing that. And this is just my sense of it, anytime before 9 months at all. But it does mention that the court, not the agency, the court can make a determination at some point.
Right. And don't you find too, David, that there are some tribes who are very small and may not have an enrollment member come in and look at these inquiries for once a month maybe, and timely that.
And to your point too, if some of these are tribes who have fewer resources and have smaller memberships to begin with, you know, if just one child who is lost to their community can be a huge factor. Not every child is important, but this is especially, and we saw this actually in the initial legislative hearings, that there were tribes, because they had so many of their kids removed and lost to them, that they were really starting to question, what's the future going to hold for us if we don't have tribal members to carry us forward? You know, we need our children to help us be able to continue to survive. So I would say the other thing about this is that sometimes, that direct line of communication from, let's say, from you or the caseworker or somebody in the court to the tribe may or may not get you where you want to go. But sometimes it's about relationships too. So it's thinking about, okay, well, if I don't know if this way isn't working, what's a different way? That's where the Bureau of Indian Affairs might come in handy. If they know that tribe, or they know somebody in that tribe who could help you get the relationship or the response you're looking for. So thinking about those kinds of ways to get information, just additional ways.
Right. And here's one from Kurt. And the tribe that I dealt with required a child to reside on tribal property to become a member. And I think that's where that sovereign nation comes in, correct?
Yeah. Some tribes have residency requirements, and it's not a lot of them do, but a few do. And so that's that just shows you how unique it can be from one tribe to the next. So you might want to, that's why you have to be careful about, I think here many of these tribes seem to use these kinds of measures. And then you find one that is yet another factor. Another example is some tribes use that you have to have your descendancy has to come from either a maternal or a paternal relative. And so that's important. That could be another factor. So you never know until you actually, until the tribe makes that decision, and then you have a better idea. But really, you're just trying to get that response of, does this tribe consider this child to be a member or eligible for membership? That's all you really need to know.
Got it. I think that's about the question. Some of these, David, I'll be able to answer, or I'm getting answers from some people who are from the department as well. So I think we're okay here. Thanks.
Great. All right. Well, we'll move on to our next
Okay.
slides. So jurisdiction. This is one. I'm not going to spend a lot of time on this. We could talk about this for quite a while. But the state court must make a determination of the residence and domicile of the child. And this is to determine whether or not the state court actually has jurisdiction. So I'll give you an example. So let's say that you're working, a child and a family come to the attention of the agency. There's been some report of abuse or neglect, and so there's an investigation that begins. So in this situation, you might find out that the tribe already has the child and the family are already a ward of the tribal court. So they have active ongoing proceedings in tribal court, and this is where the tribe has jurisdiction. So in that case, the state should be dismissing their jurisdiction and returning maybe working with the tribe on returning the child and family back to the tribal agency if that's necessary. So it's important to know that this question about who has jurisdiction does have to be sorted out. In a child advocate role, you may not have a really big role in this, but it's worth asking the question: have we determined anything about the residence and domicile of the child, and about whether or not the state court or the tribal court has jurisdiction? Now, and we'll let the legal people figure that out, but we want to make sure that we kind of get that right, because it's very important. And I also would say, adding on to that the state, even under the Child Welfare Act, still has the ability on a temporary basis to respond to a child whose safety is at question. And that's that temporary jurisdiction they have is to come in and investigate, and then they can return the child to the tribe, but they have the ability. In other words, we don't just leave the kids and families by themselves and say, well, we don't have jurisdiction right now, so we can't. No, the state can intervene to ensure the safety of the child, but it's a temporary jurisdiction they have, not an exclusive jurisdiction, for instance. So I mentioned before, there's the right to transfer to tribal court. So the right to transfer a case from state court to tribal court exists. The parent can ask, the Indian custodian can ask, the child's tribe can ask. So you've got a number of people, and they can do this at almost any point in the different proceedings. There is, however, and this is in the regulations as well as in the statute, the transfer should occur unless either of the parent objects to the transfer. And in this case, either the parent means native or non-native, as long as they're a birth parent. Or if the tribal court declines jurisdiction, they might say, well, I'm glad that the parent wants to transfer the case to us, but we don't have the capacity right now, or we're going to decline jurisdiction. And then the last one is if good cause exists. So the state court can look at that. Maybe somebody brings this up in court and says, I think there's good cause not to transfer the case. So we've certainly seen that over the years, where one party is challenging whether there should actually be a transfer or not. So here are some of the good cause. These are restrictions. You notice how I've got that in italics. So what it tells the court is what they can't consider. So the court can consider a number of things in whether good cause exists not to transfer. But what they can't consider is whether or not the case is at an advanced stage, unless the tribal parents have not received notice prior to that advanced stage. So if they weren't receiving notice along the way, and then there was a challenge to the transfer of that case, the court could still consider it. But if people have had notice along the way and the case is advanced, it's the court may decide that their good cause exists not to transfer. It's a little tricky, the language, but hopefully it makes sense. The court can't consider whether there were prior proceedings where transfer was not requested. So you might be almost up to termination of parental rights when the transfer is going to happen. But what people might ask, well, why didn't they transfer this case earlier? And I want to talk about that just a little bit. So many tribes, tribes are not unlike states. They have to consider their resource base. And so in those situations, all right, there we go, get it back again. So if the tribe is offering some services but can't offer all services, they might be looking at they're developing relationships with the state agency and the courts and trying to make strategic decisions about when to transfer case and when not to. If the case starts out with reunification and the tribe feels good about the case plan and the way people are proceeding with that, they may not feel that there's a need to transfer the case at that point. But what if and this happens, it's not uncommon, where the case plan changes and maybe they say, well, we were working on reunification, but now we're going to move to termination of parental rights. Well, many tribes don't support termination of parental rights. They support permanency, but not with this kind of standard termination of parental rights you see in many state courts. And at that point, the tribe might feel motivated to ask for a transfer because they don't trust that this case is now going in the direction that they would support. They could also be looking at whether the court can't look at whether the transfer would affect the placement of the child, whether the child might be placed with a different family. The court can't consider whether the child's contact with the tribe or community is significant in their mind. So that's not permissible either. And the court can't consider whether the certain socioeconomic conditions or any negative perception by others of the tribe or the BI social services or tribal court exists. That's not for them to draw conclusions about. They're really looking at just at the transfer of jurisdiction. So those are very important pieces that the court has some limitations about on when they're looking at good cause and hearing arguments. I'm trying to get my my controls back. They've run away again. Shoot. This happens sometimes. Okay, here we go. So emergency removal, we talked a little bit about this earlier, but the state can exercise temporary emergency jurisdiction. And then you see the language, imminent physical damage or harm. What's important to realize about this is that the state, in their own state laws and regulations, may use a different standard than this, and many do. The word threat often appears in state statutes. And so it's important to think about, in this standard, which applies in ICWA proceedings, are we meeting the standard, or are we sort of sliding to maybe the definition that the state uses? And we want to make sure about that, because this is actually a higher standard than many states use. So that's important to realize too. And then the emergency removal part. So previous to the regulations being published, what we found in a number of jurisdictions is that Native families were being brought in through an emergency child custody proceeding, and it was being called emergency, and then they were having their children removed, and then that emergency proceeding, without moving to foster care or some other kind of proceeding, was continuing in some cases as long as a year or more. And this highly restrictive to parents when you do that, and not fair to them, because they don't have the opportunity to really move forward when they're in this emergency custody proceeding for long periods of time. It was never designed for that either. these kind of emergency custody proceedings are just a measure to kind of help protect the child initially and determine whether or not there's a cause exists to maybe file for a dependency, a foster care proceeding. So here in the regulations, if it's an ICWA case, it's not supposed to go beyond 30 days unless the court makes all of the following determinations below, and you can see what those are. So those have to be met. If they can't, it's possible, and certainly in some cases that you might see, you need to go beyond 30 days, but it should be the exception and not the rule. And so I really ask people to look at this one very closely. We're in the front end of this case, and let's make sure that we're not holding on to emergency custody proceedings for months and months going on after that initial removal. Tribes have a right to intervene in any ICWA proceeding at any point in that proceeding, and that involves both involuntary or voluntary proceedings. And it has all the same rights as other parties in the proceeding, the agency and others as well, and the parents and their courts. And of course, this is so relevant to right now, right? With the pandemic, courts should allow alternative methods of participation. Many courts do and have been doing this prior to the pandemic, but of course it's become even more of an issue. And I think there's some really good practices that are developing around this. I will say this though, two things. One is that not tribes may choose to intervene at some proceedings, but maybe not all proceedings. Again, this could be a resource issue for them, and also a strategic issue around how they feel the case is going. And so we have to look at it that way. The response of the tribe is unique to that tribe usually. And the other thing I would say about this is that we've had, not so much now, but previously, we've had a lot of the family court hearings or proceedings be delayed. And because of those delays, of course, that's created a lot of anxiety for parents, family members, and even when we're offering technology or alternative technological ways to participate, lots of the families don't have that capacity. They might not have the hardware to actually technology to do that. They live in areas where they don't have broadband. So I think this is a great place for child advocates to be in making sure that we're helped with it. All of the parties have sufficient and adequate opportunities to participate. If you've ever been part of it, and I'm sure you probably have, a hearing where somebody on the hearing doesn't have good connection or something, you know what that looks like. And so we want to make sure that we're doing everything we can in advance to help people be able to participate in these hearings. So here's our next chat box exercise, and here I'm asking the question, what's the benefit for the child and family of early engagement with the child's tribe? And that might seem like a really obvious question, maybe I've already mentioned, but I'm thinking, let's think a little deeper on this. And so what are some of those benefits for early engagement with the child's tribe? Go ahead and put those in the chat box, and then Laura Lee is going to take a look at some of these and share some of her observations.
These are good questions, David. From Jan, staying in culture, form connections to support child development in the culture. So far, David.
Lots of things you could say about this.
Yes, yes. Early engagement could reduce trauma.
Yes.
Minimize change. More options for placement and support.
Yeah, I think that's really critical, that the earlier we get involved, the more opportunity we have to make mid-course corrections. That's what we talk about in our office sometimes, and in child welfare proceedings and cases, that we're always having to adapt. So the more time we have, the earlier engagement, and it takes a while for those plans to be drawn up and then put into place. So that's a good one.
And here's one from Lisa, tribal resources for the child, relative searches, potential transfers.
I agree. And
Yeah.
as we remember, and here's another one. So you may be working a lot of times with younger school-aged children, but you may also have a case where you've got an older child too. And that older child is probably trying to figure out what's my voice in all of this, and how can I, because they have the capacity, many of them do, to be able to understand what's going on and be able to participate too. And ICWA actually includes a provision related to that. So I would suggest that early engagement with the child's tribe can help you learn more about the child, the youth that you're working with, and help you engage with that child or youth even more effectively too.
I think so. And I think that's where, if they're placed in a non-native home, that we can help the foster family maintain, give them resources to help them maintain that cultural bond.
Good comment.
Yes. Okay, here's one. Dietary needs better met both culturally and by child's individual health.
Excellent.
Tribe decisions better and more involvement with child and family. Okay. Just a lot of support, uncertainty for the kids,
Yeah.
and ICWA is that gold standard.
Sounds like there's a lot of really good ideas, and a lot of people are really chiming in on this one.
Yes, yes. Okay, one more. That's it, David.
Okay.
A lot of support.
Good. That's great. So people are, I think they're really seeing the benefit there. That's great.
Yes, perfect.
So this slide has a little bit more information about intervention, like tribal intervention in a case. And this is not anything you'd find in the regulations or the statute or on the BIA website probably. But this is something that we developed in our office because we got a lot of questions from people who are participating in ICWA proceedings about, well, what does tribal intervention look like? And in some places, people have boiled it down and said, tribal intervention is when the tribe actually transfers the case. That's tribal intervention. And there are judges who have shared that that's what they thought it was too. Well, it's a much bigger continuum than just transferring the case. So I've kind of tried to summarize it a little bit into 3 categories. So monitoring the case, that's one level of intervention. It doesn't mean that you'll necessarily participate in any of the hearings in person or all of them for sure. But you will be you'll be reviewing the information, the court records, because you have the opportunity to do that when you intervene as a tribe, because you're a legal party. Maybe there's other information too that you'll be looking at. And sometimes you might make recommendations, and you might filter those recommendations through the court or the agency. It just depends. So that's kind of the lower level. That's, and especially for tribes that have fewer resources and have smaller child welfare departments, this might be where they are at with a lot of their ICWA cases. So an active participant is somebody who's monitoring and participating in some or all of the hearings and also reviewing the materials. So this is probably the kind of participation that you'll see from a lot of tribes, and understand too that some of the ability to participate, if you're, especially now with virtual hearings, probably means that this can change. But if you're even tribes with larger resources, more significant resources, I was thinking like the Cherokee Nation of Oklahoma, told me that they get 1,000 notices a month, and they have a robust sized child welfare program, but 1,000, that's a lot, because you have to remember there's work to be done once you get the notice, trying to figure out what your plan is and how you're going to implement that plan. So many of the times, I think Cherokee Nation would be, in many of their cases, would be doing this active participant role, not because they don't have a lot of resources or significant resources, but because they just have such a quantity of cases and before them. And then advanced participant is a really active, this is like co-case management to me. And so you could see some of that in the others too, but this is definitely one where you'd see that, where there's really active participation both with the agency and the court, making recommendation, assisting in the coordination of services, maybe even offering services in some cases. You will probably see this more likely in cases where the child's tribe is in the same state and than you would if the child's tribe was in another state somewhere else, maybe halfway in another time zone or something. So this is just to help you kind of think about that. This used to be one of the questions I get from judges is like, what is this intervention? Why are some tribes doing it this way? Why are others doing it that way? And so I try to explain when I can about what this might look like, knowing that it's fairly unique to each case and each tribe that's involved and sort of the kind of where things are at. So in involuntary foster care placements, we're now moving on beyond application and jurisdiction and also kind of the basics around emergency proceedings. Now we're at foster care dependency placements. So there's 4 requirements here you can see. So one is this, it's called active efforts, and that's to provide services to prevent the family breakup. This can mean both to prevent on the front end so that the child doesn't have to be removed and can stay at home safely, but it also means preventing the breakup by helping the child be, after removal, be returned safely to the family as well. So it's both. And unreasonable efforts is another standard that you often hear. It's a standard that gets applied in non-native cases around the country everywhere. Active efforts we think of as a higher level of effort. I'll talk a little bit more about this later, but active efforts is definitely as similar in that it's both preventing and then helping reunify in this case. The next one is the evidentiary standard that is used or should be used by the court in determining whether or not they're going to order this foster care placement. So they're using clear and convincing evidence. This is higher than what many states might use, which would be a preponderance of the evidence. So it requires a higher standard. So again, you see that language in here. It's like that you have to look at that evidentiary standard and apply it to the question of, is this continued custody of the child by the parent going to result in serious emotional or physical damage? That language of serious emotional or physical damage, it could very likely be different than the standard that your state uses, because they might again use they might use the language of threat, for instance, and that's different. The third area is qualified expert witness. This is somebody, in many of these cases, the qualified expert witness, especially if the tribe has not intervened, is not participating in a particular hearing or proceeding, this might be the only person in the room who has what I would call, real cultural knowledge that could be very valuable, because as we know, the courts are asked to make determinations, to make decisions about a number of different things all along through the process. And in order to make the best decision possible, they need the best information possible. And before the Indian Child Welfare Act was enacted into law, what we saw is that this kind of information, the cultural information especially, the context was not provided in cases, which made it easier to apply a non-native kind of assessment or judgment of what was going on, which oftentimes was inaccurate and led to unnecessary removals and separations of children from their families and communities. So the qualified expert witness, I'll talk a little bit more about what that person could look like, who that could be. That's a really key part of these hearings. And then, of course, the last one is placement preferences. So when the child is placed in out-of-home care and what would be a foster care placement, the placement has to follow the placement preferences of the Indian Child Welfare Act. And we'll talk a little bit more about that too. So the Washington State Indian Child Welfare Act also talks a little bit about this and adds a little bit more information. And it says that you have to make good faith effort to place the child within the placement preferences. So here's my example. So if you're doing a really diligent search of relatives and family, friends, people who could be a placement, then you're likely going to be able to meet the placement preferences in many cases, not always, but in many cases. But it takes some extra work, right, to figure out the relative, the extended family network, and what kind of availability they have to be a placement. What is not a good faith effort is if you ask the parent or parents, so tell me about, do you have any relatives that might take this child? And they say, well, I'm not sure, or I don't know, or something. And you go, okay. And then you mark it down. Well, I guess there's really not much else we can do here. Well, we've got this other foster family that doesn't meet the placement preferences of ICWA, but they're available right now. That's not a good faith effort. So we need to work harder to make sure that we're as early as possible, making sure that children are placed within that placement preference. They also talk about in the Washington State Indian Child Welfare Act that any harm that might result from interfering with a bond or attachment that has been formed between the child and a foster care provider shall not be the sole basis or primary reason for continuing the child in foster care. So in other words, if somebody says, well, and I would say this is especially true with a non-native foster placement, and we see this increasingly happening where somebody says, well, the child's been in my home for a few months now and they've bonded or attached to me. I don't think you should remove the child from my care and place them with this relative or extended family member or tribal member because we've got this attachment, and if you remove the child, bad things will happen. So they've made it very clear, and this is actually, we'll talk a little bit more about bonding and attachment, but really the science behind bonding and attachment as we know it today is much more advanced than some of the arguments that are made in courts about whether people are bonded and attached and what the impact would be if a child is removed. And so we saw a lot of case law on this before the regulations were released and before the Washington State Indian Child Welfare Act was enacted, that was indicating that it was a real mixed bag. In many cases, judges were very influenced by people saying, well, even without a scientific basis for it or a factual basis, to just say, well, they said that they're worried about this child having some kind of additional trauma that will be unrepairable. That would be the kind of language that would get used if the child's removed from this foster family. And so maybe we should just keep the child there, even though we have a relative here or somebody else in the placement preference. And they just found that for a court of law where we're really trying to base our decisions on the best information, factual information, this is I call it an upgrade, because we're trying to understand what exactly do bonding and attachment, how do they work from our current understanding of it, and also adding the cultural context of this too, because a lot of the early bonding and attachment literature from basically the World War II and in the 50s continues to get used, even though we understand so much more about it. And a lot of that early bonding and attachment literature or research was looking at a very kind of ethnocentric view of what is a family. First of all, a family is just this nuclear family, mom and dad and kids, and not giving any credence to the attachments and bonds that people have with their families and their culture. And so we have much more information about that now than we used to. So I think this is important to understand. It's going to be with us a long time. We know that there are more and more people who are coming into the public child welfare sphere looking to adopt kids. And sometimes what they're doing is they're challenging court proceedings and asking to keep native kids in their home and using this argument, even when there are other homes available to that child.
David, didn't NICWA put out an article on bonding and attachment?
Yes, we do. We have resources too, and I'm gonna.
Yes, and I think I have that, and I will try and make sure that that gets out to the participants because it was beautifully written. So I will make sure that they have that.
Okay, if you have any questions about, I can put it in the chat box too.
Oh, that would be great too, David. Thank you.
Link. I might do it towards the end as we get closer.
Okay. That's great. Thank
I'm not going to talk really very much about this. This is really just looking at child welfare as it's generally acknowledged should be working. And really what this says is that you see all families at the bottom, we call it the slope. It's very large at the bottom and then it gets narrower at the top. Well, this is really examining the kind of needs that exist within different families for different kinds of supports and services, and the resources that should be allocated in each of those areas. So you can see as you get closer to the top, fewer resources. The thing that's interesting about this is that we realize that if you just go up the first several boxes, the first 4 boxes, that there are, even the first 3, you actually see a lot of families need extra support. All families need prevention and basic needs and services, information and support. It isn't until you get halfway up here that you start to see more of the kind of families that we see in child welfare where the risk is already documented, typically in many cases. But look at the top. We don't get to out-of-home removal until we're almost all the way at the very top. The thing about this is that up until more recently, the way that the federal government and many of the states funded child welfare is that most of the resources, the bulk of it, was up at the top where these out-of-home services are, and the fewest amount of resources was down here at the bottom, where we have things like family support, prevention, and basic needs and services. I think that's changing some. I don't think we're at a balanced place yet. Our systems, our tribal, state, child welfare systems, federal financial system doesn't look like a balanced system yet, but we're getting closer to that. And for those of you who have heard of the Family First Prevention Services Act, that's the most, and since 2018 now, Title 4E services can also be, you can reimburse for prevention services, which is really great. But we've still got a ways to go. But I would offer that to you as some evidence that we, as the system, as families and children's needs are established, we have to recognize what's the system's capacity to respond in kind and in the way that is most effective too. So some examples of what you might be thinking. So what's appropriate? What are appropriate situations for family-centered services? Well, we've been talking a little bit, we just mentioned that active efforts, and active efforts includes things like in-home family-centered services. So situations where it's not appropriate is if you can't assure the safety of the child, that's probably not going to be a situation where you would leave a child at home and just offer family-centered services. And that's what we're talking about here, where children are at home. When you have parents' ability to maintain safe levels of care is below a minimum level, or children don't have or have special needs that cannot be met at home. Now I look at this, and this one gets used maybe too often sometimes. And the way it gets used improperly, in my opinion, is that sometimes, even though we have family members who are living in more remote rural areas, and they don't have the same kind of services access that people maybe in urban areas or suburban areas have. We should be doing a better job of making sure that there's equity in the ability for all families to get those services they need so they can help maintain and support the special needs of their children. So just saying, well, they don't live close to the hospital where they have these certain services or the medical clinic or something. We should be thinking about what are the creative ways that we can actually make sure that that family can continue their relationship with that child and keep the child safe and get those services. That's the advocacy that I think sometimes is missing in this case. We give up a little too easily. And here's some other examples too. You've got to have parents willing to accept help, of course, and then they have to be able to recognize the needs of the child too. So these are critical factors here as well. But there are plenty of examples of when in-home service, family-centered services with children at home are appropriate. So the children are at risk of placement and the parents demonstrate a willingness to accept help. That's critical. We need to see that. Children have been in the placement and are returning home. So sometimes we've got the post reunification time, and sometimes that's we're all happy when the child's going home, but we have to realize that's a transition because the child's been out of the home. And even though the parents may have been improving their own capacity, it's a transition. It's a new dynamic for them and the child, and that there needs to be proper support. And so I really urge you to advocate for post reunification services. You want to make sure the parents are recognizing the child's needs, and that you can still assure safety even if you need to do more frequent home visits. Sometimes I've seen programs that are trying to keep kids at home, but they're saying, well, the most we can do is maybe one visit a week, or one visit every 2 weeks, or even once a month. And many of these families are going to need much more support than that. They can do it. There's a lot of the things that exist that say that they can do it, but we're going to have to make sure our programs are structured in a way that we can be there to help them with the daily things sometimes that they may be struggling with as they develop more and more capacity to be able to parent and keep their kids safe. So we also have to make sure, those services are available, but these are all situations. And I think sometimes we lose sight of these. That's why I put these in. This is not ICWA, Indian Child Welfare Act required, or it's not a matrix from that, but it's more of a practice issue. And I think it's a good way to think about, is this a situation where instead of taking a child out of the home, we should be thinking about in-home family-centered services, or is this not a situation like that? So we need to be able, as child advocates, to think about that. And I mentioned earlier that I saw reasonable and active efforts have, from a kind of 30,000 foot level, have very similar purposes, preventing removal, helping kids get home after removal successfully. But there are some differences in the level of effort that's required under both. And so active efforts actually has much more definition to it, because in the Indian Child Welfare Act regulations, reasonable efforts has very little definition, but we know a lot from just the way it gets applied and the way it gets talked about. And so if I break this down, what it really is about engagement versus information and referral. So we can manage and we can refer services, meeting those minimum policy standards. But active efforts requires us to go on to a higher, more engaged level. And that includes making sure that services are culturally appropriate, not just do they match the kind of service we need, but are they culturally appropriate? I think our families can actually, and our kids can actually, in many cases, tell us if that's actually happening. We can have conversations with service providers and ask just a few kind of strategic questions and figure that out probably as well. So I really think this is an important part of understanding and lifting active efforts to make sure that we're not slipping down into reasonable efforts sometimes, even though we're calling it active. And this is probably one of the most critical core issues around ICWA being successfully implemented is, are we providing real active efforts? And so I encourage people to look at this and kind of use this as in the Indian Child Welfare Act. Let's see if I think it's next slide. There are 11 examples. I pulled these out right from the regulations. And this next, I think it's 3 or 4 slides, yeah. And these are high level enough that they could be applied in almost any case. But at the same, they have enough specificity to it. I think you could almost think of this as a checklist in some cases. And in asking yourself, have we done all of these things in this particular case? Because if we haven't, maybe we haven't provided active efforts. And it's interesting to me because when I see people who have been working with active efforts for a while and have gotten good at it, they can step into for instance, a scenario, a case scenario, and very quickly tell you what was active efforts, what wasn't active efforts, and how to change that. So I would encourage you to keep talking about active efforts because I think it's the kind of conversation that we need to keep continuing. Well, here's our next chat box exercise. And this is asking you, about how you assess whether active efforts are or have been made. And then how do you support active efforts in the cases that you're involved in?
I'm so glad that you talk about this, David, because I think it's a real important aspect for advocates to continue asking and looking at active efforts. So thanks.
I'm going to take a quick break here, Laura Lee, and I'll be right back, but I'll let you go ahead and watch the chat and talk with people.
Perfect. You bet. Thank you. And throughout this training, this ICWA Institute this week, you will hear more about active efforts, and it's really stepping outside of a box, you might say. So here's one. Don't give up after one return telephone call. You know, and that's where keeping in touch with the social worker on a regular basis, as well as the tribal contact you may have, ask questions, review case documents. Are these active efforts? Yes, and asking the question of the social worker as well, seeing where the social worker is, seeing what the parents are involved in. Ask questions and communicate with team, yes. Follow up continuously with social worker. That is one of the greatest things that you can do, is build that relationship with social workers, tribal contacts, as well as the parents. The parents, you know, will give you a lot of history and what they believe maybe would work for them. Ask about barriers to progress. Ask questions. You're all right on, and it's just really thinking on a, like David said, on a much larger scale. Pay attention. Is there proactive work going on? Not just waiting for someone else to make efforts. That's the team, staying in contact with the social worker, with the ICWA social worker from the tribe, and talking with parents. Have to be persistent when asking all of the child's contact. I think everybody, David, has an understanding of this. Here's one from Greg. What can the Casa do without stepping out of the advocate role? You know, Greg, that's a really good question. And I think that's where maybe your supervisor or I can answer that personally, because you do have, I don't know what county you're in, so it's going to depend on how you are getting your information from your supervisor, because there is a fine line. You want to be able to be a team member, but you cannot do the social worker's job. I like to say you can be a thorn to make sure things are happening. Okay. David, I think we're done here. Thanks.
Okay. I'm trying to find my controls again.
Okay. Okay.
I disappeared and so did they. So.
You're back though. You'll find them.
I hope so. It's not really up to me. It's up to the technology.
Yes. Yeah.
It's they just disappear. A couple things while I'm kind of trying to figure this out about active efforts is that it is exactly what you said, Laura Lee. It's the responsibility of the state caseworker and their agency, or even a private agency in some, you know, voluntary case maybe, to provide the active efforts. And some people I've heard say, well, what we really need to do is just call the tribe, and then they're the one that's going to provide the active efforts, you know. And that's the tribe can certainly support and inform and plan with you on that, but it's not their job to provide the active efforts. It's really clear. On the other hand, I would also, as we talked about earlier, tribal engagement is really critical. And so you might come up with what you think is a great active efforts plan for the parents and the child, and then realize later that, oh, I missed a couple things here. So what we want to do is make sure that you're looking at all of those things in your work with the tribe. So they should be your partner as much as possible in trying to develop those active efforts. Okay. So qualified expert witness, well, that's the next very important requirement here, and I mentioned a little bit about it earlier. The qualified expert witness oftentimes is somebody from the tribal community, and it's highly encouraged that you talk with the tribe about do you have a qualified expert witness in this case that we could borrow. Now, the qualified expert witness, this is not like an expert witness in, let's say, a criminal trial or some other kind of civil trial. The qualified expert witness testifies to the information they're required to provide, but regardless of who pays for their time or supporting their participation, they are not witnesses for the defense or witnesses for the plaintiffs, the prosecutor. It doesn't work that way. This is really about more of a neutral, objective position where people are providing information to help inform the court, that includes the judge, of course, about whether or not this action, like we'll say in this case, a foster care placement, is appropriate or not. And so the one prohibition that the regulations from ICWA do state is that the state caseworker assigned to the case cannot be the expert witnesses. And so sometimes we acknowledge that sometimes it's hard to get qualified expert witnesses. Maybe the tribe doesn't have one, or the BIA office in the region doesn't have one, or you're just and so that can become a challenge. That's why a lot of tribes and states are working on QEW projects together to try and recruit and maintain more of those folks. But check with the tribe and make sure that you aren't leaving it, hopefully, to even really anybody in the state. I have my own bias, which is I think that it should be somebody who's not working for the state who's providing that QEW, although it's possible it could be somebody else. I've known situations where the supervisor for the caseworker who was assigned to the case provided the QEW. I'm not comfortable with that myself. Technically, it might be something that you could do, but I don't think the potential conflict of interest is there, and I think I would avoid that if at all possible. So enough said about QEW, but it's a really important part of understanding sort of the context and whether or not this is the right decision to remove that child. And the QEW themselves, these are the things that they testify to. They're going to be asked to testify to their own qualifications. They don't have to be psychiatrists or psychologists to do this. In many cases, they might be elders from the community or other people cultural people from the community who understand sort of the history of the tribe, the way child rearing looks in the tribe historically and traditionally, and giving some light in it. One of the things that happened during pre-ICWA is that we had lots of children were removed because the social worker from the state came onto the tribal lands to the person's home and then said, well, look at this, where are the parents? Well, the parents weren't there, but there was a relative there. Maybe it was an aunt or an uncle who was providing care. And they said, well, this looks like abandonment to us. And so then they removed kids that way. Now, the extended family network, as I mentioned on the first day of training, is really important to that helping system. And it doesn't mean that children are abandoned because their parents aren't there. People have different roles. So you can kind of get an idea of the flavor of why the QEW can be so important in helping interpret that information and understanding it better. Could affect the outcome of a decision about whether to remove a child. They also testify whether the foster care placement standards and adoption placement standards have been appropriately applied and whether active efforts have been provided too. So all of these are things that have some weight in the QEW's testimony and are things that they may discuss. So here's another place where the Washington State ICWA law also contains some additional clarification and language. They say when the tribe is intervened, or the petitioner is the department, and the tribe has a local agreement. Many of the tribes have local agreements in Washington with the department, or the tribe has not responded, the petitioner must contact tribe and request a QEW. And the request must be at least 20 days before the hearing. Very important there. So they're adding a timeline there as well. And then they say the characteristics and order of preference for the QEW when the tribe does not interview or does not have a local agreement, or the tribe does not respond to requests for QEW in a timely manner. So there are some situations where it could look a little bit different, but those agreements, the contact with the tribe, those are going to shape the kind of QEW you're going to get probably and who that might be. And they say here, it cannot be the department caseworker or their supervisor. So they've taken it to that next level in the state law, which makes sense. So here's the last of the 4 major requirements around foster care. And this is that the placement preferences start with a member of the Indian child's extended family. That can be defined by the tribe, so the tribe can have its own placement preferences, and you should inquire about that. And that extended family could be native or non-native, depending on the family, the composition of the family. So that's important to know as well. The second preference is a foster home that's licensed, approved, or specified by the child's tribe. This could be on or near reservation in the state of Washington. And an Indian foster home that's licensed or approved. So this could be a state licensed home of a native family that is not necessarily from the same tribe of the child. And lastly, this is the institutional one. So when I mentioned earlier that foster care placement includes institutional care. Here's one where it talks about children who are placed in those institutions or residential facilities, congregate care facilities. And that place has to be approved by the tribe, the child's tribe, or operated by an Indian organization that's suitable to that child's needs. This is the order of preference too. So this is an order, isn't just starting at one place here. And I think the institutional one is the one I see. We're moving away from institutional care in the United States in a couple different important ways. But what I see is that oftentimes when Native children are placed in residential care, the child's tribe is not always necessarily contacted and asked, is this something, an institution you would approve? And I think that's important. And I would go back to active efforts as well as placement preferences and say, this is it's important to plan with the tribe and not just be updating the tribe. So planning with the tribe means you're talking about these options, these decisions together, not just saying later, okay, hey, here's the service we're providing to meet active efforts, or here's the placement that we're going to use for this child, and then saying, is that okay? That conversation should happen from the very beginning, and should include the tribe as an equal partner in that. And I mentioned these two before. It can include guardianship or conservatorship, and then of course different placement preferences. The tribe, this is a question you need to ask, is the child's tribe, is do you have your own placement preferences here? Because those can be substituted for the larger, either the state or the federal ICWA law placement preferences. And in some cases, one of the parties could assert that they believe good cause exists to not follow the placement preferences. So it could be a request of the parents after they review the placement options that are ICWA compliant. So it's a request. Again, this is not a this is not a mandate. Or it could be the request of a child if they can understand the placement decision. Then we're talking usually older children. Or if there's some presence of a sibling attachment, that the only way it can be maintained is through a non-ICWA compliant placement. Another couple things about good cause and placement preference is that the extraordinary physical or emotional needs of the child can be considered as part of good cause, but that doesn't include ordinary bonding or attachment that happens in a non-compliant placement. So of course, children are going to bond and attach to caregivers and others that they're in contact with. We expect that. In fact, that's important and helpful. And one of the things that it's helpful to, I think, just in terms of bonding and attachment literature, is that when children form bonds and attachments to other adults, and those are positive, supportive, that actually helps them be able to establish additional bonds and attach to other adults in their lives too. So they build on each other. It's not that they're exclusive, they actually build on each other. That's something that not everybody, I think, and maybe in the courtroom understands. And so if you don't have an ICWA compliant placement, after a diligent search has been located, so you have to show that you've made a diligent search, and that search was using the prevailing social and cultural standards of the child's tribe, then you might be able to grant good cause. And again, similar to what we talked about earlier in other areas, the courts can't consider the socioeconomic status of one placement versus another. In other words, if this placement seems to have more resources, they live in a neighborhood with more resources compared to this other placement, that should not be a deciding factor about good cause. Here is some of the information, and actually about that Laura Lee was brought up earlier. You can see that I've got, I think these links at the bottom still work. I think I checked those, but anyway, this is sort of a summary of the paper that we've written. A couple papers, one about bonding and attachment, another about the benefits of relative care. They're both on our website under the foster care section. And you can see a lot of what I kind of discussed earlier, talking about some of that earlier information about historical trauma. And that identification, this is the third bullet, it's very important, with a particular cultural background and having a secure sense of cultural identity is associated with higher self-esteem, better educational attainment, and protection against behavioral and mental health problems. So culture, as I mentioned in the very beginning last Friday, it's more than just what we do or who we see ourselves descended from. It's really about, it's highly prescribed to our ability to have successful lives and protect ourselves against some of the risk factors that are around us. So promoting strong cultural identity and connections is in and of itself a way to help protect children. So, and there also is a body of study that also shows that there are negative effects associated with being forced to acculturate to a culture that is not your own. So there's potential harm there as well. And this idea about trauma earlier in life is irreversible does not really account for the large body of study that we know about currently. And so that's important. And then also looking at developmental niches, that studies that look at that, they also reveal the importance and consistency throughout different parts of the environment in cultural values and practices and identity. So it's really good that we have so much more information. We understand the relevance and the strength of what having a strong cultural connection and being grounded in that means. And I think this is the kind of evidence you might be in court sometime when these kind of questions come up. And this would be the kind of information that would be important to share, I think, with the court, to have them be able to become more educated too about some of this literature and some of the science as we know it now. And there will be situations where people will say, well, I can provide for the culture of that child, even though they are not Native themselves. And there are certainly things that non-Native people can do to support positive cultural identity in children within their care. There's no doubt about that. But we do also have to realize that Native families are going to have access to very specific experiences and values and beliefs and customs that are not going to be available to non-Native foster families. And it's very powerful to have children connected to those who have those connections themselves. So helping pass down the culture, because the transmission of culture is something that happens across our lifetime. It's not just a moment here or a moment there. It's a constant across our lifetime. So it's really important to realize that too. We know sometimes Native children will be placed in non-Native homes for different reasons. So that can happen, and we want to support those caregivers when we need to do, when they're caring for those kids. But we want to also realize that we should be doing everything we can to try and support placement within the child's culture. So really key to understanding that.
Even I wanted to mention that one of my coworkers actually put that site in the chat box already for us.
Oh, excellent.
Yes.
There we go. Fantastic.
Yes. A lot of good help out there.
I'm going to do, we are at about 12 minutes before we're going to end. So I'm going to move through this chat box exercise, Laura Lee.
You got it.
Things because I want to get through. So this is a slide that this is not an NICWA slide necessarily, but it's about red flags. And I really believe when our daughter was young and she was growing up, they used to talk about, they didn't use the language of red flags, but we talked about your uh-oh voice. And some people might call it your spirit. Other people might call it sort of your conscience, whatever. But we have to kind of be aware of the things around us as best we can and pay attention to what's going on so that we can avoid bigger problems in the future. Now, we all know about this. We all know that's true. So in child welfare practice, one of the things that we want to look at is, are caseworkers ensuring visitation is occurring on a regular basis? So one of the biggest determinants of how quickly children will be coming home, returning home, and how successfully they will be returning home. So right now during the pandemic, I know visitation has certainly been struggling in a lot of ways, but we have to really, really think about how can we make it, and we can develop and support the best kind of visitation possible, so that we don't deprive both the children and the families of the ability to have that connection. And with regard to foster parents, we want to be asking questions about whether they understand and are communicating to the foster parents that they have a role as a temporary placement and supportive case plans with birth parents and relatives. Almost, I've never seen a licensing standard that didn't have a statement about this, and the foster parents, of course, are trained to this and sign a piece, usually an agreement about this to become licensed. But it's like a lot of things, the foster parents are getting inundated with a lot of different information. And the longer the child's in the home, the more the importance of this becomes, especially when we're trying to get to permanency. So we want to also be asking about if foster parents have appropriate understandings of attachment and bonding too. Not to deny that they have an unimportant role or an unimportant attachment, but to think about this within the greater context of attachment and bonding with other family members and their culture. And then helping prepare those foster parents for the transition and placement that's going to have. Too often, I think what we see is that as we're preparing and doing our case management, our case planning, we know when things are going to start to change and transition. Unfortunately, sometimes the foster parents don't get notified about that until much later, or if it's discussed with them, which you would have to be, they're not getting enough information to help them be supportive during that transition. So it also speaks to the ability to get the kind of foster parents that we want to be able to provide what is a very important role, but also comes with some real challenges too. So we want to make sure that people have a good experience. And so is the case documentation complete and detailed? Very important. I know that, you know, if you ask any social worker, ask me, you know, we will tell you all the time that the value of the work that we do in the field with people is the most important. But the documentation is important too, because if it isn't documented and detailed, it didn't happen. I mean, it literally, it's hard in a court of law, especially to prove that it happened. It's your word against somebody else's. So making sure that there's good things happen, that is happening as well, to the best of your ability. Just asking a question, you know, how are we doing on the documentation and things like that? And is the tribe being engaged early and often? Are they being asked to participate as opposed to just being updated? So really important. So watch out for the yellow or red flags, depending on where things are at, and just ask questions. You can ask it in a really respectful, you know, and but trying to help make sure that we don't run into these issues later. Most of the contested cases that we're aware of usually happen because some of these things did not happen. It's not because there weren't good intentions in many cases, it's because these kinds of things didn't happen. And people, when we have surprises, that's when we can get into conflict. Termination of parental rights. These have, as you can see, has very similar to foster care, very similar requirements. Active efforts have to be made. They have to have evidence here. The standard's higher. It's the highest level of evidentiary standard, which is beyond a reasonable doubt. And it's, again, it uses that language of continuing custody is likely to result in emotional or physical damage. Compare that to what your state might use. Most states for termination of parental rights don't use beyond a reasonable doubt. They're going to use something like clear and convincing. So it's a step down. You still have to have the qualified expert witness. And if you're terminating parental rights, you should probably be working towards an adoptive placement. And it could be a customary adoption, but usually a customary adoption does not usually include a termination of parental rights. And when I say customary adoption, I'm talking about tribal customary adoption. So as a child advocate, you might ask the question, it looks like we're moving towards adoption. Is the tribe supportive of the adoption and the termination of parental rights? Have we looked at tribal cultural adoption? Is this tribe supportive of that? Do they use this? Is there a guardianship option here? These are all questions that we should be looking at before we get to termination of parental rights. And then in the Washington State Indian Child Welfare Act, they talk about that any harm that may result from interfering in the bond or attachment that may be informed shall not be the sole basis for termination of parental rights over an Indian child. So it's similar language that they used over in foster care as well. And then adoption placement preferences are also similar, but not the same as foster care ones. It starts with child's extended family and then moves to other members of the child's tribe, and then of course, just other Indian families. And this is the order of preference. In the Washington State ICWA, they actually include a definition of tribal customary adoption, which I think is interesting. Not many states have that. And they also say that they included an additional placement preference, any other family which can provide a suitable home for an Indian child. So suitability is determined not by just the caseworker, but in consultation with the Indian child's tribe or under proceedings. And they mentioned, here's the citation, where the child's tribe has not intervened or participated. That last acronym, LICWAC, you may have heard of that, stands for Local Indian Child Welfare Advisory Committee. They operate in different regions in the Washington state. And it's usually a group of, body of usually Native people within that region who are hearing different cases, Indian Child Welfare Act cases, many times cases where there is some complexity or some contested pieces to it, and trying to provide to be a support and actually provide guidance. So you may have worked with a LICWAC. If you hadn't, they can be a resource sometimes. There are protocols around when they get used and when they don't. But ask your regional child welfare specialists for the department and ask them for some more information about that, and you can easily learn about that. Here are the voluntary places. The thing I'm going to share about this is probably about all I will say about voluntary is you'll notice that notice in voluntary proceedings is not required by ICWA. This is the federal law. Intervention is, tribes can intervene in any voluntary proceeding, but not the actual kind of legal notice. However, it's a good idea. It's a best practice. And certainly the regulations and guidelines encourage that. But there are states where they have their own state law, which does require notice in voluntary proceedings. And Washington is one of these 8 here. So even in a voluntary proceeding, you should be providing that legal notice to those proceedings. I'm going to skip some of these pieces here and you can get to know those. And here's a website or a slide on some tips for engaging tribes, developing relationships. You can take a look at that. And I want to get to this piece right here. We did some research to look at some Native youth in the Portland area and their risk levels for, things that can cause problems, obviously, in their own functioning and their family continuity. And we were able to see that when Native youth had access to many of these kind of what we would say on the left side are protective factors, things that protect, you can see that they had lower uses of and engagement and risk factors, and they had greater kind of increased school belongingness, increased hopefulness about the future, and many other positives too. So it's always a good question to be asking, what are the protective factors in every family? And what are the strengths of this family? Even some families who are really struggling, they all have some strengths. And we want to really be doing the best we can to identify those and work to help nurture those too. So here's what I'm going to end. I'm going to say thank you very much for participating in the training. I always enjoy, like I said, it's one of my favorite trainings of all the year. And Laura Lee and Ryan, thank you so much for your support and your help in doing this. I couldn't have done it without you, of course. And I hope you have, all of you, I hope that this training helps you be able to provide that level of advocacy that you're hoping to provide for all Native children.
Well, David, as always, you always start this institute off in a good way, and I'm just so appreciative. And tomorrow I will share information about the conference coming up, as well as how to become a NICWA member, because you do so much for our communities, Indian communities, that I think everybody, and just the trainings that you do and just everything that you stand for in your mission to help Indian children and families just captures my heart always. So thank you. Thank you. Thank you. And I appreciate it. Tomorrow, everybody, we're going to have the Washington ICWA law by Lori Irwin and Casey Looney. So stay tuned. David, you just enlivened me with your presentation as always. So thank you. I honor you.
Thank you.
Same for me as well, David. Thank you so much for continuing to be such an asset to our child advocates here in Washington State and for the children, and especially the Native American children that they serve. So thank you so much for you and your organization's continued commitment to make sure this institute gets started off in the proper way.
Great. My pleasure.
Good.
Thank you.
Thank you. My best to everyone there. Thanks, everyone.
Thanks, everyone.
Bye.